and welcome to another episode of BLG News for the week of July the 15th. I'm Marcus Boston.
And I'm Renee Boston.
And today we will talk about some of the big stories that are in the news for this week, namely the Trayvon Martin verdict, which was rendered on Saturday, in which George Zimmerman was found not guilty of everything pretty much in that case. And we've had a lot of people on our Facebook pages and stuff ask, well, you know, BLG, what are you guys' thoughts on specifically the Trayvon Martin situation? And what we're going to do is we'll talk about it a little bit, but we're not going to get specifically into what Florida law is for first-degree murder, second-degree murder, manslaughter, and all of those things. But we're just going to talk about, I guess, Renee, you know, you can talk about some of the issues that that case presented and how the prosecution went forward with it.
From my understanding, and just from an outsider's perspective looking in, it seems as though there was pressure for George Zimmerman to be brought to trial from some form or fashion. And the police department in Sanford, Florida, declined to really investigate at that time when Trayvon lost his life in February of 2012. I believe it took about either 40, 60 days or something like that before George Zimmerman was even arrested on any charges surrounding the death of Trayvon Martin. The governor of Florida had to appoint a special prosecutor, and he named Angela Corey of Jacksonville or Duval County, and her and her office brought charges against George Zimmerman and prosecuted him. They actually charged him with second-degree murder, and the trial began about 2 or 3 weeks ago. Mm-hmm. And the issues that were surrounding the trial from the onset, from a legal perspective, is did the state have enough evidence based on the lack of investigation from the police department, the evidence that was collected after the fact, and pretty much George Zimmerman's statements, any kind of witnesses, whether the testimony, what they heard, what they saw, things of that nature. Did they have enough to proceed with the higher charge of second-degree murder, or should they have charged the lesser, which is the manslaughter? And legal analysts had been arguing back and forth from the beginning. The Facebook legal analysts and laymen have been arguing back and forth as to, did the state ever have enough to charge the higher charge, or should they have defaulted to the lesser charge of manslaughter? And because they charged the higher charge, you know, they built their case around the higher charge. Right. And it seems towards the end, they realized that they were kind of grasping at straws, and then they asked for the lesser included charges of manslaughter, and I believe they threw in an assault or something like that.
Yeah, they threw in some more other things, but let's talk specifically too, Renee, about the fact that they built their entire case around the higher charge, the murder charge, and even some can argue that the fact that the jury was asking for clarification at the end about manslaughter kind of suggests maybe the jury didn't even really understand how the manslaughter charge
and that's the way I took it. When a jury asks questions, and we do trial work, when juries ask a question, they really want clarification on that specific issue. They may not know how to word the question to get the information that they're seeking, but they're interested in learning more about that and how the evidence and facts play into whatever that question is, whatever that charge is. Right. There are actually jury instructions, and those jury instructions kind of go through the elements of, in this case, a criminal case, to kind of go through the elements of what offense is charged and what the state would need to prove in order to find this person guilty of that specific charge. And what most prosecutors and defense attorneys will kind of do is go through element by element to either, you know, point out what they did prove from the state's perspective and what they didn't prove from the defense perspective. So it's clear if the jury was that confused during their deliberations. I think they deliberated like 16 or something hours.
Yeah, I believe it
that
was.
They didn't have enough. No one sat them down and said, "Hey, okay, now this is what we need for manslaughter. These are the elements. These how the facts that we've provided you for the past 3 weeks fall into place with that."
And you can even take it a step further. I don't even think was manslaughter even mentioned earlier when they even opened, when they gave their opening statement.
Well, how it's usually done is that when the jury's presented, when the jury pool is first assembled, they're told that you're here today for this type of case, and these are the allegations against so and so that occurred on whatever day and whatever time and whatever location. So in this case, I'm pretty sure it read something like, you're here to the state versus George Zimmerman. He's been charged with second-degree murder of the death of Mr. Trayvon Martin occurring February 2012, whatever the specific date was. So at that time, when the jury's first sworn in, they're told that those are the particular charges. And sometimes it can be quite confusing to a jury that 2-3 weeks later, it's one thing if the case is open and closed within a day or two, but when you go from almost a month's time frame, and then all of a sudden now you're adding charges, the jury can really, what's going on? Where did this other stuff come from? They never told us anything about that. And if you're not, as a prosecutor or a defense attorney who's seeking the lesser included charges, if you're not weaving the other charges in throughout your evidence and your questions, then you're not giving the jury the baseline in order to properly evaluate and decide on a fair and just verdict.
And I think that's where a lot of people are getting confused, because if you look at, even up here under Maryland law, if this was a case that would be something that's up here in Maryland, and you're looking at manslaughter or murder or something of that nature, a lot of times when you do have fights in situations like that, it becomes manslaughter, because it's hard to determine whether that intent was there.
Right.
That if you look at Trayvon's situation,
murder is an intentional.
It's not right. It's not in most jurisdictions, the intent level is not the same as what it would be for a murder. And I think that these legal concepts are very complicated at times to understand and to be able to deal with. And that's why it's very important that prosecutors, when they take these types of cases, take the time to set their facts up in such a way that the jury can understand, okay, this is how we reach a verdict of whatever. And then you also, Renee, I know we got time's going, but you may even want to talk about that big burden that the prosecutors have in criminal cases, and that's beyond reasonable doubt. You want to talk about that for a little bit?
Doubt is you're not certain whether or not you should take your jacket out because it may rain today only because it rained yesterday. Reasonable doubt is a doubt based upon reason, meaning what a person in a like-minded situation would believe in similar circumstances. Beyond reasonable doubt is mean pretty much you got to have it all. You got to have all your ducks in a row, and you have to be very, very certain, like almost absolutely certain, not quite 100% positive, but as close as you can humanly possibly be to 100% certain that what you said happened is what happened.
Right.
So it's the highest burden in our judicial system. So it's important that the state has to properly prepare their case, properly identify witnesses that correlate to each element of each charge, to prepare their case and to present it to the jury. Yeah. That's what the trial is about. The trial is about presenting the information to those. Well, in this case, in Florida, it's 6 people. In Maryland, it's 12 people for a criminal case. And you prepare it and you present it to them. You want to present it to your jury on a platter. You don't want them to be missing anything. You want everything right in front of them so it's clear cut. You want them to see the case through your eyes. And I think sometimes when people want to rush the case or
do improper investigations,
right, when you're starting behind the 8 ball because your investigation was not thoroughly completed by either your office or the police department, hey, you got to either go back and fill in some gaps, or you got to wait until you get everything together.
And a good defense attorney is going to be looking to poke holes in it.
But that's the job of the defense attorney.
That's how it works. But I want to also talk about something too, which was a big issue too on Facebook, and it deals with specifically understanding and knowing your jury. Now we know we lived in Jacksonville, went to law school in Jacksonville. And Jacksonville, I'm a Florida native, grew up, born and raised down there. And Jacksonville is not Stanford, Florida.
Sanford.
I'm sorry, I'm thinking about.
No, don't mix it up with Stanford, California.
I don't know where that came from. But anyway, Jacksonville is not Sanford, Florida. It's not. And you have a different person who lives in Sanford, Florida, than you do in Jacksonville. Right. Sanford is a small town. You want to talk about that issue too?
Well,
I mean, because it's the same thing up here. Prince George's County,
right? It's not the same as Montgomery County, or not the same as those jurors on the Eastern Shore. Every jurisdiction is different, and remember, the jurors are usually selected from either the voter registration and or the motor vehicle registrations for that particular county. So the people who live there are the taxpayers, the ones who or should be, or in theory are, and these are people who are chosen amongst the hundreds or whatever for the particular jury duty. They get the call in, and they come in and they're interviewed. Usually, in specific areas, you have like-minded people. In cities, normally are the people who are, the hustle and bustle, always on the go type of people that can't sit still longer than 5 minutes because everybody's got something to do. In smaller towns, and my parents are from small towns, and my grandmother still lives in a small town. It's a slower pace environment, right. And everybody knows everybody, right. And everybody's protective of everybody, right. From outsiders. Right. So it's not necessarily we like this person or we don't like this person, but he's one of us. Right. And sometimes with that, I mean, it's not just black or white or anything like that. It's the small town, the good old boy network, whatever you're a part of. But and that's the mentality of the small town. Mm-hmm. They protect their own, and they don't want other people dictating what they can and cannot do in their own little town. So from anything from a trial or how the laws are written and how the laws are enacted and applied, right? It's different for the small town versus a big city. It
is, and that's something too that we don't know if whether the state's attorney's office, when they came in, did they really take that into consideration? They really take that, did they really understand that? We do have a lot of people who think that just because you live in a big city, that everybody thinks the same way you do. There was even a conversation about, well, everyone knows that marijuana does this and marijuana does that. No, wrong.
Well,
Charlie
let me tell
Murphy,
you about this
wrong.
With marijuana. I am 35 years old. I know people that have smoked marijuana. I know people who are younger than me that smoke marijuana, people who are older than me that smoke marijuana. And I know people who smoke marijuana that are very functional with their, it's a recreational, whatever they want to do with it. I don't do it, but that's them. But I know some people who've never touched it, and I'm one of those people. But because I have people that I know that have done it, and then they Friday night or whatever outside in the backyard, and they get up Sunday morning and go to church, and Monday morning and go to work. That's what I know, and that's what I can bring to the table. But in small towns, in these areas, people aren't familiar with people who do
may not be familiar with that.
Drugs.
The Sunday school teacher that is that's getting up and going to teach the little kids on Sunday morning may not have the same life experience and understanding of marijuana as someone else.
Right. Having lived in Baltimore, having worked in Baltimore City, and having spent a lot of time in Prince George's County in the criminal courts, marijuana in those places is not the same as marijuana in St. Mary's County, where you still have the Amish riding along the streets in a horse and buggy.
Right.
You can go outside the courthouse in Baltimore City and smell the aroma of marijuana, and because you're around it so much, you actually can identify the smell of it and differentiate that between the marijuana smoke and a cigarette smoke. Right. And there are people, and I will say my mother is probably one who does not know what marijuana smells like, and will never know, because nobody around her does it, and she's not in the areas of where people are doing it. She's not hanging out the courthouse or the jail or wherever these places are. These people are smoking marijuana. So for her, marijuana is an illicit drug, and people like her and people in small towns who aren't associated with people who have ever partook or whatever in drug use may think that marijuana is the same as meth. It may be the same as heroin. It may be the same as cocaine, because they don't know.
They don't understand it. And I think that was an issue, because that was allowed in on the Trayvon Martin, and you had a lot of defense attorneys that were saying that the state took a big hit on that, because they didn't try to head it off, either bring it up in their original case in chief, so that the impact wouldn't be as strong to the jury. They didn't do any of that. They let it come in through the defense, and to a large extent, some can even argue that helped George Zimmerman's case, because he did say that this guy looked like he's on something. This guy looked like he's hyped up on something. So you've got jurors who may not understand the effects of marijuana. They just see it as an illegal drug,
right?
And it goes to the credibility of George Zimmerman.
And that's the thing, and that's another part of society. You only know what you see. Now, if you don't have anybody in your community or your circle doing drugs, but you have these movies and these videos of people doing drugs, and they're sitting around as they're smoking drugs, they're doing, God knows what to whom, whatever. They're it's the image. It's not necessarily the smoker who's laying back and he's laying on the floor asleep. They have these images of The Wire and these New York shows of homicide and Law and Order where people are doing drugs and they're going out and shooting people and killing people and robbing people. So people think that, okay,
this is what drugs do. This is what drugs do. Right. So really, I mean, if we get ready to wrap this segment up, I hope that if you're listening to this, you can see that there was a lot that went into this case and into this, and jury trials are not what you see on TV. They take a lot of work, and everyone has to be on the same page to get the result that they want to get. And in this particular case, there were numerous problems with the state's attorney's case in the George Zimmerman case. There were a lot of problems, and sometimes the public don't necessarily understand what these legal words mean and what these concepts are. I
actually saw a post on Facebook a little while ago where somebody said, and today is a day that the majority of Facebook users have received their law degree. Mm-hmm. And it's like law, the way you think of it, may not be the way it's written in the books, and not as written in the code, and the way it's practiced. So it's in theory, it upsets you. It may frustrate you, but if you don't know the law, you don't know the law. Right. And you can get it from ask someone what the law is, but it's not. A lot of times, it's not as cut and dry as people think.
No, it's not. It's really not as cut and dry. So I think that's going to be pretty much about it, Renee, on the Trayvon Martin case for our assessment of everything. And we have, I guess, one more story that you found, Renee, that was really, really crazy. But we got one more story to talk about for this week, and this deals with a man who says that one day of P90X sent him to the emergency room. And if you guys aren't familiar with P90X, that's one of the intense workout routines with Tony Horton. Mm-hmm. And he said that one day of it, Renee.
Well, he's trying to say one day of it did it, and I think his doctor actually said that one day did it, but I believe this thing was, in his one day, he gave it all. I mean, he left it all on the table. He gave 120%. He's supposedly, as a guy who works out a lot, but I think now that's why they tell you on these videos and these commercials, consult a doctor before you begin any exercise routine.
That's right.
Because if I go out and run every day, if I run 15 miles every day, that's fine for running. I'm good at cardio and I can do that. But to go and knock out, get on
the bench press, push-ups, and do all of this,
and 175 pull-ups within 25 minutes. No. If my body's not conditioned for it, and if I haven't built myself up to it, I ain't gonna do it. Right. Or if you do it, you end up hurting yourself, which is what this nut job did.
And that's exactly what he did. So, but it's good to see that he is okay. And we would just say, if you're getting ready to start a diet or a workout routine, be sure to contact your physician and take your time.
If you want to consult your doctor, if you think you can do it on your own, ease into whatever you're trying to do. Anything probably can work out for you, but you got to ease into it. If you've never ran a mile before, why don't you start walking a mile?
Right.
And then jog, and then jog, and then actually run. So it's everything is a step-by-step process. Don't jump into something. Like, I would be foolish right now to go get the little insanity DVDs, throw them in, and think I can keep up with Sean T for an hour and a half.
You don't think
that ain't happening?
You going to think you can do it?
No, sir, not right now.
You don't think you can keep up with Sean T?
No, I can watch him. I can keep up with him with my eyes visually, but I can't actually participate in what he's got going on.
I can't either. I'll be that guy laying up in the emergency room. All right. Well, again, that's the news for this week, guys. If you have a story that you would like us to talk about, just shoot us a quick email at info@bostonlawllc.com. That's info@bostonlawllc.com. And if it's something that's appropriate as to what we have going on, we'll try to go ahead and get it in on our weekly news updates. Guys, again, I'm Marcus Boston. Thanks for taking the time to listen to us today.
Can I say goodbye to you?
Well, yeah, you better go ahead and get it in.
Well, I'm Renee Boston. Thanks for listening.
All right, guys. We'll see y'all next week.